The next case to come before the court is Jeffrey J. King v. Northwest Bankshares, Inc. et al. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. And if you do plan to reserve time, please let me know, as I'll be keeping track of time, and I'll try to alert you if you are going into your rebuttal time. Would you like to reserve rebuttal time?
Yes, but am I going to be limited to 5 minutes if I
Yes.
don't use the entire 10 before that?
Yes.
Okay.
Good question, and yes. The arguments are being recorded. When you present your argument, please introduce yourselves, keep your name, or keep your voice up and remain behind the podium. You should not use the names of children or minors or victims, should that be relevant to your argument. You can refer to those folks as by initials or general terms. And we have read your briefs and we're ready to proceed when you are, but just confirm for me again how much time you want to reserve for rebuttal.
If I'm limited to 5, I want the whole 5.
Okay.
But,
Then I will try to alert you when you are at about 10 minutes in. And you may proceed when you are ready.
Thank you. Good morning. My name is Mark Stevenson. I represent the appellant in this case, Jeffrey King. Simply put, Jeffrey King has appealed the judgment of the trial court, which granted summary judgment in favor of Northwest Bank and denied the summary judgment of Jeffrey King against Northwest Bank. This case pertains, as I'm sure you have read, to Northwest Bank's unilateral and without notice taking of Jeffrey King's $39,000 after the death of his father. Subsequent to that, after the death of his father, he had written checks to pay for his father's funeral. He had written a check to pay for improvements to his father's house as performed and done before his father's death. Those checks bounced. This was a conversion of the monies of Jeffrey King by Northwest Bank without any right to do so. There was no contract between Northwest Bank and Jeffrey King. There was a signature card between James King, Jeffrey's father, Jeffrey King, and his brother Timothy, years beforehand, with Lorain National Bank, a federally chartered bank. That signature card provided that upon the death of any one of them, really, the survivors would become the owners of the money, with the monies there on deposit. After James King died, those monies became the property of Jeffrey King and Timothy King. Lorain National Bank was a federally chartered bank. Northwest Bank became the sign on the door, or its name was put on the bank after the creation or the formation of that contract pursuant to that signature card. Northwest Bank is a state chartered bank under the laws of the state of Pennsylvania. Northwest Bank had absolutely no contractual right, based upon the evidence or the materials for consideration of the motions for summary judgment, to take anything from Jeffrey King, who owed Northwest Bank nothing. There was a demand by Jeffrey King that those monies be returned. Only a portion were, not the entire amount.
Counsel, I assume the portion that was returned was probably for the bounce checks.
One could assume that, but I don't know that.
Okay.
Arithmetically, it looks like it was, but I think it was paid. We don't dispute that was paid, that $18,000, whatever it is. I have in my brief. But the contractual rights and/or obligations of a corporation or a chartered company do not become the contractual rights or obligations of another chartered company which may own the stock.
Okay, counsel, then I want to ask you a question. What is the basis of your breach of contract claim?
The breach of contract claim was against Northwest Bank.
But there's no contract with them.
Northwest Bankshares. We did not allege a breach of contract claim against Northwest Bank, is to my recollection. And there was no contract between Northwest Bank and Lorain National Bank. To allow a principal company or corporation to the rights of a subsidiary, or the obligations and rights of a subsidiary corporation, do not become the rights or obligations of a holding corporation unless there is some kind of a contractual arrangement of some kind. And there's nothing like that in this record on appeal, or in the record before the trial court. Simply put, a bank, Lorain National Bank was a closed bank. It was. There's no evidence that the shares of stock in that nationally chartered bank, Lorain National Bank, were assigned or purchased in any way by anyone. There is no evidence of any assignment of any of the rights of Lorain National Bank to Northwest Bank or to Northwest Bank shares. Simply put, there was no mutuality of obligation between Mr. King, Jeff King, and Northwest Bank. They simply took the money and then refused to give it back, and still do so. There's also an element of bad faith on the part of Northwest Bank when it did that. That should not have been done, and the trial court erred when it granted summary judgment for Northwest Bank. It also erred when it didn't enter summary judgment for Jeffrey King against Northwest Bank. And we asked this court to do that, because construing the materials in a light most favorable to Jeffrey King, the motion for summary judgment should not have been granted against him. Construing the materials in the record in a light most favorable to Northwest Bank, they had no right to take Jeffrey King's monies. So we asked that the judgment of the trial court be reversed. We also, granting judgment to Northwest Bank, we also asked that the judgment of the trial court denying the motion for summary judgment of Jeffrey King for the return of his monies also be reversed, and we asked this court to enter a judgment on Jeffrey King's motion for summary judgment against Northwest Bank. I have nothing else to say at this point, even though I wish I could after he speaks.
Counsel, you will have your full 5 minutes on the rebuttal.
Thank you, Your Honors. Gregory Farkas of Franz Ward on behalf of defendants and appellees, Northwest Bank and Northwest Bank Shares, Inc. And I will first of all thank you for your courtesy in rescheduling this oral argument. I apologize for the short notice and do appreciate that courtesy. I'm also going to apologize because I'm probably not going to use my full time, because I think this is a relatively simple case. While there are 3 assignments of error presented, there really is an essential question. Did Judge Kobisher get it right in granting summary judgment in favor of Northwest Bank? And I would submit that her 10-page, well-reasoned opinion establishes that she did. And the fundamental issue is counsel's comment that this was Jeffrey King's money. That simply is not a viable law. Parties do not have a property interest in funds in a bank account. It is a debt that is owed by the financial institution to that person. Moreover, under controlling Supreme Court precedent, joint owners of an account have the right to take the full amount of the funds out of the account. The central problem here is that it was not Jeffrey King's money. It was the money of both Jeffrey King and his brother Timothy King. Timothy King, who owed Northwest Bank over $3 million, which was reduced to a cognitive judgment before the funds were set off from this account. That was the state of the law when summary judgment was initially briefed. Plaintiffs filed a motion for summary judgment claiming they owed the funds in the account. Northwest Bank and Northwest Bank shares responded and cross-moved for summary judgment. Based on the record at that time, there was no dispute about who the proper parties were, whether a contract existed, or whether it was a state or federal institution. On the contrary, plaintiff's own complaint alleges that Lorain National Bank merged into Northwest Bank. Plaintiff's motion for summary judgment not only doubled down on that argument, it attached a very lengthy affidavit that you will see in the record, including lengthy records from the Ohio Secretary of State demonstrating the corporate transactions that led to Northwest Bank being the party in interest.
Counsel, let me
Yes.
stop you, because that was a question I was going to ask you about the allegations of the complaint. It's my understanding that the appellees here denied those allegations.
On the contrary, with respect to the corporate form of the entity, we acknowledge those allegations. And in particular, specifically, the fact that Northwest Bank was in fact the party of interest. And as court has noted previously, plaintiffs brought a breach of contract claim based on the account agreement that they themselves attached to their complaint and that was signed by all the parties. Rule 56 specifically allows summary judgment to be granted on the pleadings. And the allegations in the complaint are judicial admissions that are binding on the plaintiff. And that rule should apply with particular force here, because none of these evidentiary issues that are now the basis of appellant's argument that there was no contract or that Northwest Bank wasn't the proper party were raised below. And if they had been raised below, they could have been addressed. And as demonstrated by the judge's opinion, if they had had the opportunity to do so, the record could have been supplemented if necessary, which we do believe it was, but it could have been supplemented and any issue could have been avoided below.
Well,
Simply-
except that is the moving party's burden on summary judgment.
It is the moving party's burden on summary judgment, and we believe that that burden was more than satisfied not only by the judicial admissions of the plaintiff, which again are considered under Rule 56 as summary judgment evidence, their own affidavit establishing that Northwest Bank was the party to the contract, as well as the evidence that Northwest submitted in its cross motion for summary judgment. All of which was properly before the court, and again, none of which was objected to by the appellants below.
So whenever appellees file their motion for summary judgment, instead of attaching affidavits and so forth, the appellees directed the trial court to look at the complaint?
We reference both the complaint, the affidavit that was submitted by the plaintiff, and...
In their motion for summary judgment?
Correct. Yeah, that was the procedural posture below. And again, in terms of the procedural status of the case right now, the simple fact is that the appellants haven't demonstrated anything that was done wrong. Nothing would change if this was remanded below. And the arguments that they're now making simply, quite frankly, are a change in direction based on the realization that the initial argument that Jeffrey King owned half of the funds in the account was mistaken. And so the arguments that they're now relying upon were not made below, and the trial court was not given an opportunity to address them. If it had, as demonstrated by their opinion, by the court's opinion, I think we would have been in a very different place. The other argument I would like to make is that while there are 3 assignments of error, again, we believe what's controlling is the fact that Northwest Bank was entitled to summary judgment on its motion. But plaintiff's position that the court's remedy, if there were an error, would be to grant summary judgment to Mr. King is just completely misplaced. Again, their argument now on appeal appears to be that the party they sued, Northwest Bank, isn't the right party. Well, respectfully, if that were even more the case, then the response would be to remand and let the trial court address those issues. And finally, I do want to address the conversion claim separately. As set forth in the briefs, and I don't want to regurgitate the law, where there is a contract, conversion is not a proper remedy unless there is a specifically identified source of funds. Conversion from money in a bank account is simply not a cause of action. And that argument was never addressed by the plaintiffs below, nor is it meaningfully addressed in their briefs to you. And so in conclusion, I'll end where I began. I believe the trial court got it right. I do not believe there are any material issues of fact as to whether Northwest was allowed to set off these funds, and summary judgment in its favor should be sustained. Unless the court has any questions for me, I think that's my argument.
Seeing none, hearing none, thank you, counsel.
Thank you for your time.
With respect to the allegations in the complaint, those allegations were informational. They were an attempt to frame the issues for the action. They were all denied, but for paragraph 6 of the complaint. And in that paragraph, it was alleged on August 14, 2015, LNB Bank Corp, Inc., and its wholly owned subsidiary, Lorain National Bank, N.A. was merged into the defendant Northwest Bank Shares, Inc. Not that they were merged into Northwest Bank. With respect to the contention that the argument that there were different entities involved, that there was, that there's Northwest Bank Shares, which is a publicly traded corporation, Northwest Bank, a state chartered bank in Pennsylvania, LNB Bank Corp, which was a publicly traded corporation before it merged into Northwest Bank Shares, Inc., and Lorain National Bank. That was pointed out to the trial court in the response to their motion to stay discovery that I filed on May 19th of 2020. I'd like to read what I said. In their pleadings, defendants have repeatedly referred to themselves collectively as Northwest Bank, but the defendants are separate legal entities. Plaintiff Jeffrey King's monies were converted by defendant Northwest Bank when Jeffrey J. King did not have a contract with defendant Northwest Bank. Defendant Northwest Bank cannot rely upon the Lorain National Bank signature card for account number 153-00242 to justify its conversion of Jeffrey J. King's $38,035.39. And then there's a footnote attached, again pointing out with respect to the certified materials from the state of Ohio or from the Secretary of State, who was what and what their status was. So the allegation or the contention that the trial court was unaware of that is not true. Now, with respect to the conversion claim, I heard from the appellee that there cannot be a conversion claim where there's a breach of contract claim. There was no contract between Jeffrey King and Northwest Bank. That's why the Chicurno case can't apply to this. That's why they cannot rely upon that signature card. The argument had been they had bootstrapped the rights of Lorain National Bank as Northwest Bank had bootstrapped that. But they can't, because there's no evidence of any, that they're separate legal entities and no evidence of any assignment of the rights and obligations of Lorain National Bank with respect to how it held monies for the King family. Again, I asked the court to reverse the summary judgment in favor of Northwest Bank. Reverse the trial court's judgment in favor of Northwest Bank on Mr. King's complaint for conversion, and to remand, to enter judgment against Northwest Bank, and to remand this matter back to the trial court for consideration of damages. Thank you.
Thank you. Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of the decision to you on the day that it's released, and will also be posted on the Ohio Supreme Court website. Thank you again.